Criminal and Civil Procedures Module. There are 9 lessons with their corresponding desired objectives to be achieved by participants within this module. At the end of these short lessons, participants should be familiar with the basic factual information applicable to criminal and civil procedures in the United States as well as in the state of Ohio. Of course, we have to have a disclaimer, right? All the information provided in these short lessons is publicly available and provides a simplified view of criminal and civil procedures in the state of Ohio for participants to gain a basic understanding. Remember, procedures vary across jurisdictions, so it is important to always check the steps in the process in the jurisdiction you are working. This information is not intended to be construed as legal advice. Participants will also be able to identify key concepts along with their corresponding legal terminology and know how to use them appropriately. Participants will also be provided resources to complete the individual assignments and are encouraged to use the same to build personal glossaries by incorporating the legal terminology used in these lessons so they can interpret them correctly and use them appropriately into their working languages. Lesson 3. General overview to identify the different types of criminal offense levels in Ohio according to Title 29 of the Ohio Revised Code. The objective here is for participants to identify the different levels of felony and misdemeanor offenses, also known as criminal offenses, in Ohio and their corresponding penalties. In the state of Ohio, Title 29 of the Ohio Revised Code lists the crimes and procedures as well as what is considered a criminal offense. In general, criminal offenses are considered felonies or misdemeanors with varying degrees for each one. In the broadest sense, the most serious offenses are the special felonies. Then the 5 different felony degree offenses would be considered serious, and the least serious would be the misdemeanors. There are different criteria that apply to each criminal offense, as well as different sentencing guidelines and/or fines that also apply if the defendant is found guilty of the alleged criminal offense. It is critical for interpreters to understand the distinctions in order to interpret them accurately into their working languages. It is important to note that in Ohio, while the Ohio Revised Code defines the offenses, it is the Ohio Criminal Sentencing Commission who develops the sentencing guidelines applicable to each offense. There is a quick referencing guide from 2015 available on the Supreme Court of Ohio website, or you can visit the listed links below the image. So what are special felonies? There are some felonies in the Ohio Revised Code that are not identified by a degree, but instead are known as special felonies. For example, murder and aggravated murder, which are likely the 2 most serious felonies in Ohio, are the ones that fall under the special felony category. This means the law allows very specific penalties if convicted, as well as whether or not the defendant is eligible for parole. The Ohio Revised Code has 5 classifications of felonies ranging from 1st to 5th. There is an example of a crime at each level, but remember there are many more identified in the Ohio Revised Code. The most serious category is the 1st degree, while the 5th degree is the least serious. Again, you can see for the most serious degree, the 1st degree felony offense is the offense that carries the longest maximum prison term as well as the highest maximum fine. Just like with felony offenses, the Ohio Revised Code has 5 classifications of misdemeanors ranging from 1st to 4th and includes a minor misdemeanor category, which is the only one that does not already include jail time. There is an example of a crime at each level, but remember there are many more identified in the Ohio Revised Code. Similarly to the felony degrees, the most serious misdemeanor category is the 1st degree, while the 4th degree is the least serious. Again, you can see for the most serious misdemeanor degree, The first-degree misdemeanor offense is the offense that carries the longest maximum jail term as well as the highest maximum fine. Criminal defendants have to respond to the charge or charges during their initial appearance in court. We will go into further detail about the steps of the criminal process in Lesson 4. This is a brief mention only. The response to the charges by the defendant is known as the plea. In the C&O legal glossary, the entry for plea reads as follows. In a criminal case, the defendant's statement of guilty, not guilty, or no contest in answer to a charge. Types of pleas. There are several types of pleas allowed by the Ohio Revised Code with their corresponding definitions in Chapter 2943. By the way, a guilty or not guilty plea may be an oral plea, but in the other cases, the plea must be submitted in writing. We will only briefly talk about the most common, which are the first three. Guilty. Generally speaking, this plea response indicates the defendant admits, did commit, the alleged crime or accepts that the alleged facts presented by the prosecution or the alleged charges are true. Not guilty. Generally speaking, this plea response indicates the defendant denies, did not commit, the alleged crime or claims that the alleged facts presented by the prosecution or the alleged charges are not true. No contest. Generally speaking, this plea response indicates the defendant is neither admitting nor disputing the alleged crime, the alleged facts presented by the prosecution, or the alleged charges. The C&O legal glossary also lists nolo contendere, which is Latin for I do not contest. A plea of no contest has the same effect as a guilty plea in a criminal case, but may not be considered as an admission of guilt for any other purpose. It also mentions the Alford plea, or a plea in which the defendant does not admit guilt, although does concede that prosecutors have enough evidence for a conviction. Not guilty by reason of insanity. Generally speaking, the defendant was not in his or her right mind at the time of committing the alleged crime. Some states use the McNaughton rule, which is a test applied to determine whether a person accused of a crime was sane at the time of its commission and therefore criminally responsible for the wrongdoing. However, my search of the Ohio Revised Code returned no results, so this would be a question to ask an attorney authorized to practice in Ohio. Another important fact to remember is that before a prosecutor can charge someone with a crime in Ohio, they have to verify that the statute of limitations allows it. What that means is that there are legal time limits for certain crimes and the charges have to be filed within those time limits. Murder has no statute of limitations in Ohio, but there are other felonies that do have different year statute of limitations. The Ohio Criminal Statute of Limitations, Code Section 2901.13, is where one can find more comprehensive explanations of the time limits for felony and misdemeanor offenses. In Lesson 3, the key points to remember are: the rules of criminal procedure provide the guidelines for how the criminal process works. There are several levels of criminal offenses. The severity of the offense is indicated by its classification. Sentencing guidelines determine the duration of the punishment and the monetary fines. There are several types of pleas. The statutes of limitations affect legal proceedings. Individual activity. Complete the exercise. Identify the criminal offenses. If possible, include the recommended prison and jail times and the maximum fines and the pleas allowed in the state of Ohio. End of Lesson 3.